I'll start with the one that you might be surprised by my answer. I'm not a fan of mediation as you might think, as everybody else is. I think mediation is a way to slough off hard decisions. But what happens is you send folks to mediation instead of have a judge decide. And you've got to be careful of that, because as a judge, you forget how you influence people, and you forget that you're sometimes wrong, and you forget that people treat you differently because you're a judge.
Alex here with a Perspectives video on the perils of mediation. We are here with family law attorney, former hearing master, and candidate for Department 11 of the Second Judicial District Court, Lance White. Let's get started. We are here with Lance White. Why don't you start off with telling us more about you and your candidacy for Department 11 of the Second Judicial District Court?
Good morning. I am running for family court because I've been there. I had the opportunity sometimes and the misfortune to be involved in the family legal system as a child, as an adult, as a lawyer, and also as a family court master for almost 7.5 years. And so I bring experience, not just credentials, not just a degree on the wall, but life experiences that I think are just as important to that job in particular as the credentials.
So one of the questions that I get sometimes from the public is the difference between a hearing master and a judge. And then some of the more technical questions have to do with the difference between a recommendation and an order. Do you have any insight or anything that you can elaborate on?
Well, to the public, when they come into a courtroom and they see somebody in a black robe, to them, that's a judge, regardless of official title. So, but technically the difference is this, is that masters and hearing masters, call them magistrates in other jurisdictions, they make recommendations, which by themselves, these recommendations aren't law. They're only law in so much as a district court judge has empowered these recommendations to be. And there's typically a period of time that if you don't agree with the recommendation, you can file an objection. And then the judge has an opportunity to hold a hearing all over again and hear from both sides.
So one of the specific details, I guess, that frustrates at least the proper person litigants is this perception that objections to recommendations are rubber stamped in a negative way, in that the recommendation is approved. Were there any moments where you came to appreciate the decision by a district judge to alter or otherwise decline one of your recommendations? And the reason I'm asking this is maybe to provide the public with some insight on your fitting into a process where you're reviewed by, not necessarily an appellate court, but by some other person, some other entity.
Well, often you only have as much evidence and as much information as you get at the time of hearing. And so there were a few situations I remember where more information was out there, more evidence was out there that didn't make its way into my hearing. And in the meantime, this information came to light. And so a party objecting was able to have the judge consider all of that. And that would have changed my decision, certainly. But more importantly, it allowed for the correct decision to be made.
So my next question has to do with the use of experts and custody evaluators. The two sides to this one have to do with one side understanding or appreciating their investigation or the role in the investigation process, and the other side, I guess, expressing concerns that sometimes it can feel like the family judge has sort of delegated their decision-making authority entirely to the custody evaluator or the expert. What's your perspective on the use of custody evaluators and experts? And I don't know, elaborate in any way that you want to on that entire question/statement.
No, you're right. I agree with you. I think often judges, not just in family court, but judges use experts as the kind of the scapegoat, if you will, or the good guy or the adult in the room on some of these issues, when at the end of the day, it needs to be the judge making the decision. And so some judges are known, even in our district, for relying on experts' opinion more than they should. And so to combat that, I think it's important that anybody offering testimony as a witness not be construed as an expert. And if they are giving expert testimony, the court needs to very narrowly define what that expert is giving testimony about. For example, if you have a therapist that talked to a child after mom and dad had a fight, there is a tendency to have that person be an expert on what custody should be. Because frankly, this person deals with children, they deal with families. Gosh, they're really smart, and this judge has a very busy docket, so okay, they won't say it out loud like that, but that is the effect in a lot of cases. And so I think it's important to narrowly define what this person on the stand is providing, make clear that this person's opinion will help. Their expert opinion is fantastic. Thank you for coming today, sir or ma'am, but is not going to be the basis upon which a judge will only make a decision.
A great answer, by the way. The next question has to do with, I suppose, the general approach by some judges in the family division. There's two sort of major approaches. One appears to be trying to get the parties to work together at all costs, and the other appears to be, I guess you could say, embracing their role in some of these high conflict situations and making a decision. Do you have any insight on those two different approaches? And I don't know, maybe go into your experience with some of the drawbacks of each, if you have any of those.
Well, I'll start with the one that you might be surprised by my answer. I'm not a fan of mediation as you might think, as everybody else is. I think mediation is a way to slough off hard decisions by the court. I think mediation is like puppies. You say puppies. Who doesn't love puppies? Puppies are cute. Who's against puppies? Nobody. But what happens is you send folks to mediation instead of have a judge decide. You go to a mediator who sometimes is not even a barred attorney in the state of Nevada, and that mediator has no idea about any power dynamics. And so if one person is, let's say, the abuser in a relationship, they might come across as fantastic, and the other person who's scared to death to be there might come across as non-responsive, not wanting to participate. The mediator's got a contract, and so he or she knows that if for whatever reason he or she stops getting people to agree, well, guess what? The contract may not be renewed. Nobody would say this out loud, of course, but this is the internal dialogue, I'm sure. So these people get pushed to come to an agreement when it may not be an agreement that is very good, if not even bad. But hey, we have them sign a paper, the mediator succeeded, their contract continues, and the judges are able to say, I prefer mediation. Mediation is best, I think, in family law cases if it's a complex issue, typically involving economics of scale, like there's several houses, there's a business, that sort of thing is fine for mediation. But if I'm mediating, if you're requiring me to go to mediation about the lives of my children and their relationship to me as a parent, I don't know that you want to send that regularly to someone that may not even be licensed in the state of Nevada just so you can get it off your rolls and say that you endorse and appreciate mediation. So that was probably not the answer you're expecting.
Actually,
I think it's an honest one. I'd like to have that sort of conversation and debate with anybody who'd like to take it up with me. And so that's not to say you can't mediate things, but it can't be a panacea for everything. On the other end, and I think can be worse, is the forced settlement. Same problems. You have courts that have a lot of work to do during a day, and if a judge leans into these parties, he or she can get them to settle today. And so I'm going to lean into these parties today, and as a judge, and here's the myth, here's the big lie, is that both of these people in a settlement environment feel equally comfortable to tell the judge that they don't want to do this thing that they can tell the judge is pushing them to do or to agree to. That's the biggest lie, because the judge doesn't want to acknowledge that they have this inordinate amount of power. And if I say, hey, why don't you have a slice of the apple, and nod, and I'm in my black robe, and you're scared, and you've never been to court before, and your ex is sitting over there leering at you, and I say to you, why don't you have a slice of the apple pie? And you say, all right, Judge, I'll have the apple pie. I get off the bench thinking, well, you know, she had her choice. She could have No, she couldn't have. You intimidated her. The environment was intimidating. And when you pushed them to settle, you didn't settle. You just made an order. And so I think that's the other side of the mediation point, is that forced settlement, that forced arbitration from a judge. And you've got to be careful of that, because as a judge, you forget how you influence people, and you forget that you're sometimes wrong, and you forget that people treat you differently because you're a judge. And I think that's something that I would keep in mind, because I saw it a lot, and going forward, and I think it's really important. I don't think it's talked about very much, frankly.
No, I think that was an excellent response, especially given the fact that, in my at least opinion or perspective, it seems to me that things that look one way from the outside, that ultimately somebody comes to the conclusion that there's sort of a counterintuitive response to, or a counterintuitive solution to, that kind of stuff really seems to me to come out when a particular candidate or attorney or judge has experience. And I mean, I think the bunny analogy really hit the nail on the head there, because it looks to people like, of course, this is something that everyone should appreciate. But then once you've started to, everything that you said is quite frankly something that I went through, and I try to avoid the self-representation that I went through during my child custody situation. But basically, yes, that's exactly all of the 100% of what you mentioned about settlement. And I like how you mentioned you'd like to have more of a discussion on it, because it doesn't seem to me like any members of the bench or bar want to have a serious discussion on some of the drawbacks to what I sometimes call obsession with settlement. But anyway, I'll go into the next question, which has to do with right of first refusal. I wonder if you have sort of another unique perspective on a right of first refusal. The main issue, or the main concern that self-represented people, my viewers and most of the public, have when they contact me is that it doesn't work in high conflict child custody situations. So go ahead and I'd say go all out on this one too.
Right of first refusal, it's difficult to enforce it correctly, and usually the folks that have the easiest time with that sort of provision are the lower conflict cases. For those that are watching this that aren't aware of what the clause means, essentially, if one parent isn't able to spend time with the child for a period of time, 4, 6, 8 hours in a row, then the other parent is given the opportunity to spend that time with the child. And at first blush, it makes sense. I mean, if it's preferable that I have time with my boys, for example, than having the boys be with a babysitter just so my spouse can say she had the children during her time. Well, no, she didn't. Child care providers did. And so it works best with lower conflict cases. In higher conflict cases, both parents, I think, are so concerned that at some future date down the road, a parent would use that as evidence that the custody schedule should be changed. So they avoid it. They don't tell. And so you have these fact-gathering missions by one parent against the other, spying on daycare, spying on relatives that are watching a child. And the clause is not altogether healthy. I think it has some really good intentions, but I think it's abused more than it actually helps. But it is a good way to get clients and get litigants thinking that, look, if you're not able to actually have the child in your care for a period of time, let's have the child spend time with the other parent for the child's sake and not necessarily your own or for purposes of calculating time spent. Beyond that, I don't know that it's particularly useful in some cases, and so I'd be careful about inserting it in every single order. I think you need to take the time to consider what sorts of cases it would be appropriate for, types of people it would be appropriate for.
I probably could go into a whole lot more with you, but we're right about at the 15-20 minute mark. So I really appreciate you coming on. You do have a unique perspective that I think the public needs to be aware of.
Thank you. I appreciate that.